Good morning and welcome to the East Brandywine Township Board of Supervisors work session for Thursday, December 6, 2018. This is today's 8 a.m. Meeting, and a reminder that a recording device will be used during this meeting. Rules for public comment of the meeting established by Resolution 2001-08. The time allotted to each individual making a comment shall be 3 minutes or less unless set by the presiding officer. Additional public comment may be granted at the discretion of the presiding officer at the conclusion of the meeting. I'm opening it up to public comment for non-agenda items. Seeing none, we're going to move. Yeah.
Cool.
And if you, again, I think you know the drill, just your name and address in the township, please.
Sure. Scott Paulus, 108 Cherry Grove Lane, East Brandywine Township. I am here, I consider this a non-agenda item because I don't see it on the agenda, just as a follow-up on the appeal for the Guthriesville Walk project. I'm an adjacent landowner. As you guys know, we got to know each other pretty well during the application process for conditional use. And obviously the board determined that the project was not a good fit for the township on a number of different areas. So it's come to my attention that they have appealed that decision, and I just wanted to request an update from the board and just remind you guys that, you know, I think you made a fair and just decision the first time around, and it was really in the best interest of myself and my neighbors and the other folks that live here in the township. So I just wanted to see, you know, what's going on with it. Have they come back with a new plan? Am I able to be a part of the process? Can I see it? You know, just kind of bring me up to speed on that, please.
And I'm going to let Kristen, I'm going to deter this to Kristen, but I can tell you there was discussions about nobody from the township, nobody from that development was at the appeal. Is that correct?
Right, so they filed an appeal from the Board of Supervisors' decision to the Court of Common Pleas. Anybody that was a party to the hearing at this level before the board had the opportunity to intervene in that appeal, and that had to be done through filing a petition. I don't believe any of the neighbors filed a petition to intervene. The applicant, Rouse Chamberlain, has presented a quote, settlement plan to the board that the board has been looking at and going back and forth with. If ultimately the board decides, yes, we'll agree to some settlement plan, a settlement agreement has to come before the public meeting for the board to vote on. And if that were to be the case, the board has decided that it would send notices to everybody who was a party below, because you would have an opportunity then to come to the meeting where the board would consider a settlement agreement and a settlement plan. And I think I would even advise that we could send that plan and that agreement out in advance of the meeting so you'd have an opportunity to look at it, review it, and then provide your comments back to the board. But ultimately, it's the board's decision whether they want to resolve the appeal and allow a different development plan that addresses some of the issues that the board was concerned about. I think one of the things the neighbors have to understand is that the use is allowed on that property. So townhomes is a permitted use in the TND1. There were some things about their plan that the board felt did not meet the code, and that's why the decision was ultimately to deny it. And, you know, whether the court upholds that is left to be seen. I mean, I feel strongly about the decision that the board made the right decision. But, you know, I don't want to say you're rolling the dice with the court, but it comes out of it. It's no longer in control of the board. It's in the control of the court. So involving in a settlement agreement keeps the control with the board, obviously with input from the neighbors. So at this point in time, we don't have a settlement agreement prepared. We don't have a settlement plan that everybody's agreed upon. But there have been discussions about that back and forth.
Am I allowed to ask a question?
Sure.
So you had mentioned that we had the opportunity to be a party to that appeal. How would I, as just a normal guy on the street, be able to know that that appeal happened? I mean, there was no notification.
Well, we didn't appeal it. It's Rouse Chamberlain.
Well, they
filed an
appealed it,
appeal.
but I mean, you said that if I was there.
Yeah, but if you're a party below, then you have the right to keep participating. And I think I made that pretty clear at the conditional use hearing, is the reason why you become a party below is that you have the ability then legally to participate in any appeal that's filed, or you yourself can appeal the decision. So.
Okay, so I could still
I don't know if you can still, quite honestly, it's a different set of rules for a party. You have to file a petition to intervene. It may not be too late to do that, but I can't provide you legal advice.
Okay.
I mean, I'm in a weird situation because I don't want the public to feel like I'm not being forthright and honest about what the law is, but I also, when there's a adversary proceeding, I can't be representing the neighbors, because at some point in time, your interests may not align with what the Board of Supervisors chooses to do on a settlement.
Okay. Okay. Thank you.
Thank you. Oh, 1 second, Scott. Right behind you.
That's okay. Almost ran into you. Good morning.
Good morning.
My name is Sandy Moser. I live on Hadfield Road. And I'm here today to talk about the Strategic Assessment Review. Many good questions were raised at past month's meetings regarding the Strategic Assessment Review, prepared by the Strategy Group. As do others, I look forward to hearing the consultants' answers to those questions. As a member of the municipal authority, I was one of those interviewed by the consultants. They were surprised to learn of my years of experience. Apparently, they thought they were only interviewing me for the municipal authority. But they found out that I'd served on the Township Planning Commission for over 30 years, and that over those 30-plus years, I've served on numerous township committees, including the creation of the ordinance that would allow for the Guthrie'sville Master Plan. I'm talking about Ordinance 02 of 2014. Anyone involved with government, in this case local government, knows that making any kind of change does not happen overnight. Over several years of talking, planning, applying for grants under Chester County's Vision Grant Program, public meetings and discussion, and a well-attended meeting with developers that could be interested in building such a community, the ordinance was finally adopted. Now, what does that mean? It means that a developer interested in building what amounts to a small business district in that particular location with the possibility of apartments could do so under this ordinance. Period. That's it. No more than that. Possibility. The key benefit to the township would be an increase in business taxpayers and a place where the township residents would be able to shop. We, the committee, hoped for a restaurant on the proposed village green. The businesses on the south side of 322 would benefit because their business could now offer safe parking in back of their stores. No more Russian roulette for their customers entering and exiting on Route 322. It would mean the creation of a business district, perhaps even one that specialized in antiques. Now, perhaps that's a dream too far. However, a notable antiques business has been located in Guthrie'sville for a number of years and could very well serve as a hub. Now, the following is from page 41 of the review. Comment 1 in the review: the majority of those interviewed did not view Guthrie'sville as either doable or feasible or architecturally appealing for potential developers. I ask, what was the expertise of those making this comment? What does architecturally appealing have to do with anything? The township was not designing the buildings, and it is ridiculous to suggest the developer would build unattractive units for their future tenants. Without identifying these individuals, this comment has no credibility. A review comment number 2. Even supporters of the initiative view 322 being a serious obstacle to overcome. Why an obstacle? Please explain. Review comment number 3. Others interviewed expressed ignorance about the proposed project, wanted to know how much money had been expended on it, strongly doubted that after a decade of planning it would ever come to fruition, questioned why so much was being spent on something about which there is so little known. Granted, working on the wording for municipal government ordinances is like watching paint dry. You've all been there, you know this. But this is how government works. Public meetings were held. Several, perhaps as many as 3 individuals spoke out against the master plan at the public meetings. Lots of questions were asked, but something about which there is so little known. An article was in the mile marker. Every one of the meetings was open to the public. Everyone was welcome and invited to attend the meetings. Their ideas and criticism would have been most welcome. Now, comment number 4. The feedback expressed by others familiar with the comments of developers invited to an open session showcasing the plan was not positive. This is absolutely not true. A developer for the Guthrie'sville Master Plan did step forward, a developer that had built such a village in southern Chester County. This developer met with the key landowner. They talked. I told the consultants this when they asked me about the master plan. I told the consultants that it was just a matter of agreeing on the price of the land, and that one of these days it is possible that an agreement would be in place. I shared the name of the landowners with them and suggested that they interview them. You can imagine my surprise when I saw that they included this false statement in the report without checking with Scott, and why didn't they interview the landowners? Weren't the consultants interested to learn what really had happened? The landowner is the McHugh family. I think just about everybody here knows the McHughes. And if memory serves, one of the 3 developers was the Duckworth Company. Now, page 41 is nothing more than whispering down the lane. How can you give them any credibility without knowing what the speaker's background or qualifications are? I say again that by not identifying the individuals, why give them standing in this review? Gentlemen, you have not been well served by this review. And thank you for giving me this opportunity to express my concerns, as I was out of town and not able to attend the October or November meetings.
Thank you.
And I'll give the minutes to you for the minutes. Thank you.
Anyone else?
Scott Brown, 102 Cherry Grove Lane. Just have a couple questions related to Mr. Paulus's questions. The communication of the hearing, is that something that we could ask you, gentlemen, to provide us in the future? Because we obviously missed the hearing.
What
The
hearing?
appeal.
There is no hearing.
I'm sorry, the appeal.
Well, the appeal, the way it works at the Court of Common Pleas is there's no hearing. What happens is the township returns the record, which means everything that was filed for the conditional use gets transmitted to the court. That was done. There's then a briefing schedule established by the court, and after both parties file their briefs, which is just arguments based on the law, then the judge who's assigned the case assigns an oral argument. The parties can go and argue their position before the judge, and then the judge renders a decision. So if the board doesn't agree to settle the matter, that process will kick in, and yes, we can advise the parties. If the board decides that they're going to entertain, entering a settlement agreement, that will have to be an agenda item on a regular public meeting, and that's where I said, yes, the board has decided that they will send notification with a draft of the agreement and proposed plan to the neighbors.
So if the board decides they want to settle, they won't decide that or make that decision without hearing from the township?
You'll have the opportunity to come and state your opinion before they would take a vote on that, absolutely.
And will you please communicate that out to the people?
Yeah, I think we had discussed we were going to send letters to the people that were interested parties during this process.
And I would like to thank the 3 of you for the integrity and sticking to what we wanted from you guys, to speak for us. So I appreciate that. And please continue to do that, because no matter what they come back with, we would like to know about that, because we want to make sure that that the people involved that we speak with in the township that are against it and we speaking for, you get to hear their sides as well, and we get them to come out like we did last time. And I think that's only fair that that any settlement should be discussed with those involved. So I do urge you, please, to not make any decisions today. But again, thank you for the integrity of sticking by it and voting it the first time. Appreciate
Thank you.
it. Thank you.
Anyone else? Seeing none, we're going to move on to the minutes of the previous meeting. Board of Supervisors, November 29th, 2018.
Move that they be approved as submitted.
I'll second.
All in favor? Aye. Planning Commission meeting, November 7th, 2018.
Move they be approved as submitted.
I'll second.
All in favor?
Aye.
Aye. Moving on, no old business, new business, the DARK 2018 Consortium dues. Scott?
Last month, Vince Vasaskis, the executive director of DARK, contacted me. They're trying to get their finances in order from past problems they've had with previous staff, and they've asked the municipalities that participate in DARK to consider an early payment of our 2019 consortium dues, which our 2019 contribution as budgeted is $15,000, and that also includes an additional contribution of $1,725 that's to be placed in their reserve fund, which they're now establishing. So basically, what I'm asking is for the board's approval of the request for making the contribution early. That way, DARK won't have to dig into, they have a $50,000 line of credit, and they would prefer not to do that. Their funding begins in earnest in the spring, so this basically would carry them forward until they get income starting in the spring, when they have a variety of camps and other activities that fund their operation.
Any questions on that?
No, I just have a concern that this is, once you start down this road, unless
Right.
there's some plan in place to make sure that they develop the reserves necessary to get through the end of the year.
That is their plan. I talked extensively with Mr. Vasaskis, and that is their plan. They've also undertaken a strategic assessment, which myself and HUD Volts will be participating in to basically set their course for the future. So Mr. Vasaskis hopes that this is going to set the stage for them not having to do advances in the future.
I'll make a motion that we advance our 2019 contribution to the Downingtown Area Recreation Consortium in December of 2018.
Shouldn't we be waiting till our budget's approved? Or what did we spend last year?
Ask Scott, I think last year, the request for, if you look, there's a
2019 was 15,000, and we're up 1,000.
11,205 was last year.
It's up 8,000?
No.
13%. Oh, I'm sorry, the participation, 13% of the people who participate in the programs are East Brandywine residents.
Right.
Additional contribution of 1,007.
I think we should just wait till we have an approved budget.
When are they gonna, and maybe you said this and I apologize, I was trying to read as you were talking. When are they gonna have their shortfall? In December? Or currently in their shortfall?
Says fourth quarter.
Yeah, the fourth quarter has been their shortfall in the last several years, and that's because of some issues where money was lost by previous staff, and it wasn't determined until the 2017 audit, and these folks had already gone.
Right, but we don't know what loss means?
It was several $1,000s. I don't know off the top of my head what that was. I don't think that the investigation ever determined what it was. Their bookkeeping in that term was rather shoddy. And they now have engaged Nancy Althouse, who is former finance director for West Bradford Township, to correct those issues.
I'm okay with the approving it early. However, I would like documentation from them, anything that they get on that investigation to us before we continue going down this path.
Okay?
All in favor?
Aye.
No.
Luke, Historical Commission membership recommendation.
Yeah, that is me. Morning, Mr. Chairman, members of the board. At their November regular meeting, the Historic Commission voted to recommend to the Board of Supervisors that Sean Alvarez be added to fill the vacancy left by the resignation of Daniel Rhodes. Mr. Rhodes's term expires January 1st, 2022. Unfortunately, as I'm looking through your packet, it appears that I failed to provide Mary with his application form and resume. So other than the length of his term and the gentleman's name and the fact that the Historic Commission has made a recommendation to appoint him, I have no material in front of you. So I apologize for that. We'd be happy to table this for the next meeting, or if you so choose, or you know the gentleman personally and feel comfortable making the motion. Otherwise, I wouldn't expect you to make a motion to appoint without any additional information.
And where are we with the historic, they're,
So it's a 7-member board. They have.
I'm sorry, no, they know him, they're happy with,
Yes, they've made the recommendation. You are the appointing authority
Right,
for
right,
the
right.
Historic Commission. But when we advertise vacancies on our various boards, we encourage people when they call and say, hey, I'm interested in this, to come to the meetings and attend a few times.
Right.
And that's what Mr. Alvarez has done. The Historic Commission is excited about his skill set being able to contribute to the team and ready to make a recommendation.
and they're low anyway on their.
They're at 6 of 7 on their
Yeah,
membership.
so I mean, I'm kind of the mindset of anybody in this township who wants to volunteer shouldn't be turned away, and especially if that particular party is interested in having them, so I'm personally okay with it. I'll leave it to these guys.
I'm fine with it. I would like to see the application, though. That's,
My apologies for not doing so.
so I don't know whether you want to table it or.
So, yeah, so let's table it, but I think we're good with it. It's just for the semantics of the application.
Thank you. This will be on your regular session in December.
Perfect. Okay, Roadmaster, Matt, for the, I also wanted to, Matt's not here?
That's not here.
Okay.
But I can take care of this because I've reviewed the,
Do you know off the top of your head, before we get into this, I had received an email about Bailey Road. Was Bailey Road striped as well as in?
all of the roads that were paved in the last 2 years have been line striped.
Okay, because this particular email came in the night that it was supposed to be done and said it was, so I was confused. I wanted to make sure that Bailey, I haven't seen Bailey Road yet, but I was just curious if anybody else did.
It was done.
Okay, good.
today's Tuesday, I believe it was Tuesday.
Yep, that's what I
It was done.
replied, but I wasn't 100% certain. Okay.
Cedarville Engineering has been working with the township and primarily Matt on the Culbertson Run Hawthorne Drive stormwater improvements design. And because of a change in the original design to work around utilities that are buried in the road, and the road is where the infiltration and storage beds are going to be located. They've provided a proposal to complete those tasks because of the changes that have occurred over the 2 years that we've been working on this project. So they've provided a time and materials proposal for designing and supplementing the plan of $8,832 and the construction administration of $19,250. Total for that's $28,082. And Matt was asking for the board's consideration and approval of that so that we can keep moving forward on the project. We've been coordinating with, let's see, Aqua Pennsylvania did a project this fall, well, actually it was summer and fall, to install new water lines in the Hawthorne Road bed. But they also have to have conflicts with Pico and Verizon because they're also located, their utilities are located in the road bed. So Cedarville has been working on that. They have plans, but moving forward, there's going to be an extra cost associated with the actual final design and the contract administration for the construction. So that's what this proposal's for.
What was the original proposal cost for the project back in 2016?
I don't have that information with me, but we're looking at somewhere north of $250,000, as I recall. The board had agreed to move forward with the project, and while they can estimate what the project cost will be, until you go out for bid and actually get bid proposals back, we won't know what the actual cost is going to be. I think they did a high and low estimate of, as I recall, between $250,000 and $500,000 for the project, and I know we've been allocating money towards that over the last 3 years to do the project. But this proposal only is for bringing that part of the project, get to the bidding process. So this will include the design and bids.
And Scott, are we able in-house to do some of the stormwater management underground?
I doubt it very much, because you're talking about road reconstruction over top of these beds. This is, I want to call it a hybrid design, but I'm not sure that we have the staff and equipment to do that,
Okay.
at least not efficiently.
But this proposal is just for the
No, I
design.
know. I understand.
Okay,
I understand,
The
but-
250 you were talking about was the construction cost to do
Right.
that. I think what Jason's question was, do you know what Cedarville's engineering cost proposal was that was
If
approved in
memory serves me
September?
correctly, it was between, we had 3 options. One was four or 500,000, one was 200, I mean, there was,
That's construction, though.
right,
That's-
right.
We're
but
back to construction.
I'm answering Jason's question,
I
though.
don't think that's what Kristen is saying. You're not answering Jason's question. I think his question was, how much was the original Cedarville proposal for design?
For them to help with the process to get it.
I don't think they gave us a,
No, they did.
They did, we approved it. But and the way I read this, it's really 2 components. So they're asking for an increase of $8,800 on the design side of it. If we go to bid and actually do the construction, then there's an additional $19,250 for administering the contract. So it's- if we get to the end of the design phase, we go to bid, and the bids are astronomical, we never get to the construction part of it.
I'd want to take a look at their original price, because it just seems,
and what is, Pannoni can do this as well, correct?
I don't know if they could at this point, because everything's owned by Cedarville. You know what I mean? It's
Well,
it's all
you're-
in Cedarville's systems, and
You're changing horses in the middle
No,
of
I'm
the
not,
stream.
yeah,
That's-
I'm just asking if
My-
Pannoni could be a second opinion on
probably,
this.
probably be more expensive to change.
I'm, again, to look at it, to see if we're in the wheelhouse. I don't have a problem with curbing this to the next meeting for Jason to get a copy of the original proposal. And then, again, this is also new for the most part, that, just a second opinion on cost would be a 5-minute phone call. So let's do that. Let's table it until the next meeting with, okay. Subdivision and zoning application. Carlino's consent to file an application with I'm sorry. Yeah, Scott, you're up again, sorry.
In your packets should be a document, review of proposed addition to the agricultural security area for David Permy and Leslie Winters. To be perfectly frank, the county and the applicant has done this backwards. The application that I saw from Mr. Permy and Ms. Winters is different than the applications that have been used since 2005, where they're supposed to submit this to the township first. What Mr. Permy and Ms. Winters didn't understand was it says to be submitted to the local government unit on the old application. The new application says they're supposed to submit 3 copies of the application with an aerial map showing the properties. I got this, and they want the township's concurrence that we're okay with the addition of this property. It's 18.8 acres to the county's agricultural security area in East Brandywine Township. One of the things that I talked to one of Kristen's colleagues, Kim Venzi, yesterday, and because this basically got dropped in my lap, I put this on the board's agenda to make sure the board was aware of this, and I've got to go back. We've got to post the property so that there's a comment period for neighbors and other residents who may see the posting to comment to the township. Also, since we have an agricultural security district, or committee, I'm sorry, the committee should also make a recommendation to the board on this. So basically, the cart's been put before the horse, in my opinion, but the county's supposed to render a decision by December 9th. So that's why I put this on the agenda, to make the board aware that this has, this application has been submitted by the owners, and we have some work to do to try and get this back on track properly.
So I'm going to jump in because this same thing just happened in one of my other municipalities. I think the statute's a little bit confusing, and so I think that property owners, and we noticed that the county website actually didn't have proper forms. My colleague Kim Venzi was actually the one that told the county, hey, you're using an outdated form. So admittedly, the process is a little bit confusing. So what I can do is send to everybody, we sort of made a cheat sheet here of what you need to do. I haven't ever gone through it from the beginning to the end, but the statute reads that the property owner, when they file the application to add their property to an existing ag security area, they're supposed to send it certified mail to the township. And once the township receives it certified mail, that triggers the township to do a publication in the Daily Local within 15 days and post the property at five different locations. You then have your agricultural security area committee review it and give a recommendation back to the board. The county planning commission also then gets a copy and issues a review. And then you actually have to hold a public hearing, again, after notice, to decide whether you want to include this property in your ag security area or not. Most cases, the townships want this. They want to preserve the land. They want the benefit. The statute is helpful in that it's a first step to be included in the ag security area if they want to then go and sell their development rights and get county grant funds to do that. So most municipalities think it's a great thing. We just take the position we want to make sure that we do it exactly as the statute says, so that nobody can challenge it and say, oh, you didn't do it right. So
Who trumps right now? Does the county, because they put it
no,
on?
the county's just a review agency. I think what happened was the property owner was confused and sent it to the county first. So we're just going to take a step back. We're going to run the ad in the Daily Local. We're going to have the property posted. And then we're going to have it, your agricultural security area committee review it, meet it, give you a recommendation, then come back to you at a future date for a quote hearing.
Okay, but if the county does their assessment by the 9th of December, that's,
Yeah, and the county's just telling you whether they agree and think that
So
it
it's
meets
not
the
binding.
requirements. And
Okay.
it's just like a review letter on ordinance. It's a recommendation.
got it. Okay.
But I'll circulate this, 'cause I think it's helpful, and I'll also circulate it. I don't know how familiar you are with the property, but obviously I can send you an aerial map so you can see it.
The property is, the original farm from which the phases of the community park were created. So it's the farm that sits behind Phase 1 and 2 of the community park.
Got it. Okay, subdivision and zoning, Carlino consent to file application with the township land.
So as you know, next Wednesday, there's a public hearing on the Carlino Giant application. They have submitted preliminary/final land development plans to develop the Waters Track with a shopping center. The protestant for that application has requested that the board conduct a public hearing. Typically, on a land development plan, it's not a public hearing process, it's just at a public meeting. But they're going to have a court reporter present, they've scheduled to do it from 9 until 4 next Wednesday. One of the objections that's been raised is that the township has not been, quote, a party to the plan or a party to the application. There's an ordinance section that talks about if whoever land is part of the land development plan has to be an applicant or a party. In this case, because the Carlino plan proposes to construct a connector road and stormwater management facilities for a connector road through land that the township owns, the township acquired that land through condemnation, technically speaking, the township should be giving consent to that land being included on a land development plan. The township is technically, I don't want to say an applicant, but their land is part of the application. And if the board chooses to approve the plans because it meets the code, then the township, the board would have to sign the plans, or somebody from the township would sign the plans as owner of the land that has been condemned. I thought it was helpful, although I don't think it's absolutely necessary, I think it's helpful for there to be something in the record to show that the township consents to the applicant filing a plan that has land that's owned by the township. Previously, at the beginning of the year, when I first took on representing East Brandywine, I was not familiar with the litigation that's been going on for many, many years. And one of the questions that I asked the board was, does the board want to continue down the path of having the connector road be built by whoever develops that track? And the answer to that question was yes. That has been what guidance has been provided to the solicitor who's dealing with all the litigation. And as of right now, the court has upheld the condemnation. So right now, the township is the owner of that land, and Carlino has been implicitly instructed to go forward with the plans. If they're going to develop that property, the consensus of the board or the majority of the board still wants them to build the connector road, and that's the plans that are going to be reviewed next week. This letter, all this letter is doing is telling the applicant that they have the consent to use township land on their plan for purposes of building the road that the township asked them to build, which is the connector road and then the stormwater management facilities. So this letter is not giving them any approvals. It's not saying that their plan will be approved. It's not resolving, for example, the Commonwealth Court's decision. They've petitioned for aliquot to the Supreme Court. If the Supreme Court takes that, then potentially the condemnation would be undone. All this is doing is saying that as of right now, we understand that you're filing a plan that has township land proposed to be developed, and we're consenting to that.
So would you advise the board then to sign that plan then? As our lawyer?
Not until they make a decision to, if the board decides that the plan should be approved and that it meets all the requirements of the code, then yes, once, if 2 of 3 board members approve the plan, then the township would have to sign the plan as the owner of the land that was condemned.
But as someone who's done this numerous times, Christian, would you then advise our board to sign it?
Yes, absolutely. And I would advise them to sign this letter, because as of right now, the majority of the board has consented to them continuing with a development plan that proposes the construction of a connector road on land the township condemned.
And that will mean no way we're going to get sued down the road? Someone's not going to come up with some litigation, Mr. Princess, they're going to come up with
Whether or not they raise it as an issue, most likely they will. Do I think it's an issue that has any merit? I do not.
As far as the, I don't think there's ever resolution earlier this year about the direction that the board was going to be taking with respect to the actual wanting the connector road.
I disagree with you.
There was no.
There was nothing, it was nothing that was discussed at a public meeting, but there was definitely executive session because there's ongoing litigation, and the majority of the board consented for Gotham Greenwood to continue to defend the preliminary objections at the condemnation action. And that's the guidance that was given, and that's been the course since January of 2018.
But as
I think
far as-
Jason used the term resolution. and
No,
he's-
there was no
he's
resolution at
correct
public
that there was
meeting,
no
sure. That's right.
resolution.
That's right.
There was a discussion in an executive session.
As far as the declaration of taking, did that declaration of taking that the township, that Jack Larkin had drafted, did that include the sewer line going across the property?
It did not.
So it didn't word it saying the sewer line?
No, it did not, first of all, I didn't read the declaration of taking, but I understand that an issue has been raised, that BVA's counsel believes that the condemnation is unlawful because after the land was taken, the development plans were revised to have a public sewer line go across a portion of the land taken. The Commonwealth Court addressed that issue and did not find that that made the condemnation illegal. The condemnation was taken for a public purpose, and that was a road and stormwater management facilities for the road. There's nothing illegal about then having the township direct an applicant to put a public sewer line, albeit it's a line that's going to provide sewer to them, but it's ultimately going to be dedicated to the municipal authority, and others could connect into it in the future if other development plans came down the road. So I believe that the Commonwealth Court has addressed that and has held that that does not make the condemnation unlawful.
But as far as the actual public sewer line, who's going to be responsible? Because that's not really a public sewage line, if it's just feeding that shopping center. It would be a,
It would be
that'd a
ultimately,
lateral.
it would be dedicated to the portion I think that's going to be in the Eleanor property, proposed to be, would be dedicated to the municipal authority.
But as far as the whole thing, I don't understand why, if this first plan was submitted in 2011 and hasn't changed much, and it had depicted a sewer line going across the property back in 2011, and the declaration taken was only drafted in 2014, why wouldn't we include
I think at the time,
the actual verbiage of sewer lines to avoid any future issues?
the previous plans, if my recollection is correct,
Station.
indicated that there would be a pump station, and it was going to be pumped west out of the property over the hill and then down Bollinger Road, I guess, to the treatment facility. So that's been modified because my understanding is that, and I do recall, when we did the Keats Glen development, we had Rouse Chamberlain extend the sewer main in Keats Glen all the way out Brookhaven to North Guthriesville Road in anticipation of connecting additional properties to that pipe. And we also made sure that the pipe was adequate in size to be able to accommodate those additional properties. So it makes sense from the municipal authorities' standpoint to have a gravity feed line there rather than a forced main going out the other direction, and that's why this modification was made.
But as far as the actual, whether it's a pump station or gravity, it's still going through the property. Why wasn't that language included?
Because it wasn't
Wasn't part of the
something that was
plan.
being considered at the time. The plan, until very recently, the plan had the pump station and the sewer main was going the opposite direction. So this plan now incorporates, and there was no way to get it through because it was somebody else's property. So it wasn't anticipated, and these plans have a certain amount of fluidity to them, so
Yeah, but right now, though, the planning module, or back then, the plan module was changed if the land became available to utilize the gravity line for the alternative methods of conveyance. And the DEP approved that, even though, as of right now, I believe today, it still depicts a pump station, but it's still going through that property. As far as, I think that, in my opinion, I think that we need to get a second opinion as far as,
you want a
just because
second
the sewer line-
opinion on the Commonwealth Court decision?
No, a second a second opinion on the actual legality of,
You've had my opinion, you've had Jack Larkin's opinion, you've had the trial court opinion, the Commonwealth Court opinion, and the federal court opinion. There's 6 legal opinions that support the position that I'm advocating right now for the board.
Kristen, but that was all in a different plan.
It doesn't matter. The legal issue is the same. The legal issue of the condemnation is what you're arguing about, and that has been litigated, argued, and disposed of in favor of the township.
Well, I don't understand. If you are going to give us our legal opinion, why wouldn't you have read the declaration of taking?
I read the Commonwealth Court opinion,
But
and
why
I
not?
understand, because you didn't hire me to read the declaration of taking.
I
You-
asked
the
for a legal
board-
opinion on
The
the
board
sewer line,
asked for
Kristen.
the Gothrop Greenwood firm to continue to represent them in the Carlino ongoing litigation, which included the condemnation matter. I have given you my legal opinion. The fact that you don't agree with it doesn't mean I'm going to change it.
I asked a question about a sewer line going across and.
And I responded to you, and I cited the Commonwealth Court decision, and I cited the law. Again, I can't convince you that I'm right, so
But
I
it
don't know.
doesn't say a sewer line going across there.
There-
That was the whole.
I think you have to understand that the Commonwealth Court is a panel. It's not one judge. Am I correct?
That's correct.
So there are 3 judges on the Commonwealth Court that looked at this issue and unanimously decided that there's no merit to that argument.
I'm not talking about the actual merit of condemnation. I'm talking about the sewer line going across.
But that's the issue that you're talking about. What I believe Mr. Prince is arguing, although it's very difficult to decipher through his email, I believe what he's saying is that he believes that because the township took too much land in the taking, because part of what they took will have a sewer line across it, that land then has been abandoned and has to be returned back to LNR. The court dismissed that. They said that's not true. It is not illegal if the original taking was for a public purpose, which the court upheld, that then there's an incidental benefit to a private party, which a sewer line that will service a private developer is an incidental benefit that's not illegal as long as the original purpose of the taking was lawful. Even if the plans had the municipal authority's original plan to have a pump station and the pipe go west, if that's the way the plan got approved, the road got built, et cetera. If during the course of construction, the municipal authority said, you know what, we don't want to own a pump station. They're costly, they're expensive, they break down. We'd rather you do a sewer line, a gravity sewer line. They have the ability to direct the applicant to put a public sewer line in township public land. And that's what happened. It's just happening sooner. It's happening before the plans go through the final approval process. And again, I'm not saying they're going to get approved. I'm just saying that that's what the municipal authority often does. They look at a property that is required to have public sewer under your ordinances, and they say, what's the best way to provide public sewer to this site? Is it a pump station going west, or is it a gravity line going east? They determined, after the declaration of taking was filed, that it makes sense better from a sewer perspective and a sewer planning perspective to have the line go gravity sewer across land that the township owned. And the township owned that land through a proper lawful condemnation.
I understand, but it would be considered a lateral, not a public sewage line if it's just serving one site, one location. It's not public if it's one location. That's a lateral. So the tap-in would be at Brookhaven, the public sewage. So
As I just
who-
said,
what else is it, what other public is it gonna feed if it's just that shopping center? There's no,
there may be somebody in
benefit
the
to any
future
other-
that will
where-
connect into it. I don't know. I don't know enough about it. I'm not part of the municipal authority. I wasn't involved in the process in that. That's what I've been advised about. And even if that line stays a private line, that is an incidental benefit that, again, does not make, there's case law on it that does not make, for example, if SEPTA or SEPTA had to condemn land for purposes of building a SEPTA train station, and on the first floor of that SEPTA train station, they decided they wanted to lease out some space to a Starbucks, the fact that they have an incidental private benefit to a Starbucks does not mean that their taking of the land for purposes of a public transit station makes it unlawful. The courts have held that. So in this case, the public taking for a road and stormwater management, if then the township wants to, through the municipal authority's direction, advise the developer that they can put a private lateral, that does not make the taking unlawful.
well, I think,
And I'm not sure how that has bearing on what is the agenda item today, which is that the board has implicitly allowed Carlino to move forward with its plans, directing it to build a connector road on land the township condemned.
I'm concerned because the sewer line was depicted on that plan a long time ago, well before the condemnation, and even the language in the taking did not include the sewer line. That was my concern. And secondly is, back in 2011, Judge Nagel remanded this plan back to the Board of Supervisors because their land.
At the time, the township didn't own the land.
Because at the time.
Right, now the
No,
township owns the land.
The applicant, not the township. The applicant did not own the land. And therefore, you
the
cannot
township.
depict development on others' property without them being an applicant.
And that's not happening in this case.
Well,
I
we
think-
are the owner and we're not an applicant.
I think your statement is incorrect, that the other property owner has to be an applicant. They don't have to be an applicant, they have to consent to the applicant's development, which would include facilities on their property. And that's to prevent an applicant from coming in and proposing something on somebody else's property that they then turn around and say, no, we don't agree to that. So we have to consent to them including our land on their development plan. That doesn't make us an applicant for the project. And that is my reading of this proposed letter.
But the second sentence in our ordinance states, if ownership of the entire tract is held by more than one person or entities, the application shall identify and be filed on behalf of the said owners. Approval of the plan shall be conditioned upon agreement by the applicant or applicants. But wouldn't that mean the applicants being us, so we're an applicant?
I don't necessarily think you're an applicant. Carlino has submitted plans with the township's consent to use township land to develop the road that they were told they had to build. So I understand what you're reading, but I think the point is that as long as the township consents to their land being part of the application, part of the plans, and if and when the plans get approved, the township will sign as the owner of that land, that meets the code requirement.
But right now, we're on the cover page, the township's land is located, the Township Board of Supervisors is located on the top.
Right, because
As-
you're
as-
allowing them to use your land. That's exactly what this letter is
But that's,
confirming.
but then they're saying that we're an applicant.
So what if you are? Well, you're not the one that processed it. I mean, I view the applicant as the entity that is processing a plan to be approved. I don't think the township is processing that plan. The township is saying, yes, we condemn land because we wanted you to build a road, and you had the consent to put our land, township's land, on your plan. Whether you want to call the township an applicant, that's fine, go ahead. They're listed as an owner on the plan. I think we're sort of saying the same thing. I'm not sure what calling the township an applicant has to do. The township clearly did not bring the plans and present them to the planning commission, present them to all the outside agencies, present them to the historical commission. The township's involvement was to condemn the land, consent to the use of the land for purposes of building the road.
Exactly, and there's a sewer line across there, and you mentioned the sewer line on this letter, and it's 399.47B, that's zoning. You can't, that's a zoning
Title his opinion.
issue,
right.
so why don't we just have them go through the zoning hearing board?
What
For a
would they go,
variance.
explain that, what you mean. Who would they go to the zoning hearing board for? What would they be filing for? Who's the other party that would have to be an applicant? I'm not understanding.
I don't appreciate, the tone, I understand why you can't just have it.
Well, because I don't, because we've had this dialogue through email, and because I'm
Haven't
not giving you
responded
the
to
answer
me.
you want, you're gonna continue to challenge me.
No, you did not respond to me, Kristen.
I
and-
did respond to you,
And why
Jason, 3
didn't-
times.
Did Jack?
After
did-
Jack responded to you twice, I responded 3 times.
When did Jack respond to me? Jack doesn't even know about
March
this letter.
13th, 2018,
Mar-
which is what I
I'm
responded to
talking about this
you.
letter of.
I'm done.
If Larkin is a special counsel, why didn't he weigh in on this? If our zoning in the East Brandywine Township says that all landowners need to be an applicant, we're a landowner, then we need to be an applicant, or there has to be a variance. I don't understand how else we can do this. We can't just waive zoning. So I think that we need a second opinion. I don't think this needs to be done right now anyway, but I don't think that's, my opinion.
I'll make a motion that we authorize sending the proposed letter consenting to the use of the two parcels, the proposed letter as dated September 7, 2018, to Peter Miller.
And based off of the recommendations by solicitor, I will second, but I would also like to state that with the gravity feed, I think overall, I would rather see that regardless of what the situation was versus the pumping station. Obviously with the municipal authorities' recommendation on that, I think it makes sense.
I think could we get rid of the sewer line on there? And then I would probably be,
I'm sorry, say again?
could we get rid of the sanitary sewer line on this letter? That way, but there's no issue? Is that
The
even?
plans show a sanitary sewer line on it.
Yeah, I think you have to have a sanitary sewer line. But again, this is not the end of this discussion. We can still entertain it. All in favor?
Aye.
Aye.
No.
NVR, Weaver Track, conditional use hearing, extensions through 1/31/19.
Make a motion, we accept the request for an extension on the NVR, from NVR Homes on the Weaver Track through January 31st, 2019.
I'll second.
All in favor?
Aye.
Ordinance and resolution for consideration, a resolution 26 of 2018 authorizing and directing the transfer.
This is me again this morning. Every year about this time, we transfer funds from the general fund to the unencumbered capital reserve funds for projects in the coming year. That amount is typically based on how conservative, both in revenues and expenditures, we were in budgeting in the current year. This year, staff is recommending a transfer of $560,000 from the general fund to the capital reserve fund. I would note that both funds remain unencumbered. We just make the transfer to the capital reserve so that we can plan for future large purchases like road resurfacing or vehicles and the like.
I'll make a motion, we adopt Resolution 26 of 2018.
I'd like to, as far as the capital reserves fund, if this is leftover, can we remove the money from the capital reserves account for other things?
Certainly. If we had an operating shortfall, let's say in a lean month, our leanest month would be late February, early March before real estate tax start coming in. The first place that you would borrow from would be the capital reserve because that is unencumbered.
Okay. That's what I just wanted to make. I'll second Jay's motion.
All in favor?
Aye.
Thank you.
Public comment on agenda items.
Question for you, Kyle. Number C, for under 4,
You want to ask him to come up?
is your main concern with the
Sorry. we-
Mike Wagner, 241 Jefferson Road? Cedarville, your question with their scope of work, is that what you have no one to oversee that or look at it?
Supervisor Winters had asked if we, and I honestly don't remember the total amount of costs that we had projected this to be, other than the workload. He was asking if we knew what they had quoted us to do the work to get it to that point.
Okay.
So what I was saying is reaching out to Pinoti just to say, hey, are we in a good ballpark if we're at $30,000 to get this to the point of attack, or could we be a lot less? That's all.
Well, my concern would be switching gears.
Oh,
while-
I definitely
while
don't
we're
wanna switch
midstream.
gears. No, trust me.
It's been expressed, once you start changing streams, you give it to another company, you're then looking at other expenses with that. Now, with that said, Cedarville, anything that Cedarville has done for East Brandywine Township, we own as the township. So
Right.
we can request any type file that we need from them at no expense from that. But when you start changing, you start adding additional expenses.
Yeah,
in.
and I was the point of contact for this, so myself
So
and
my
Matt.
secondary question is, do you need additional professional help in reviewing those contracts? Because I do this all the time. with what I do within land development. So I look at contracts from consultants all the time. If you need an
I
extra
would
set of
have no
eyes,
problem
I'll
with
be more
that.
than happy to do that.
Yeah, absolutely. Like I said, I mean, this is German to me, just being quite honest with you, on what budget costs should be for getting to this point.
Okay.
So, yeah, that was my only, with his concern of, where we quoted $5,000 for getting this to fruition, and all of a sudden now it's 38,000 or 30,000. That was my only argument.
Well,
But it's,
we have to rein in costs like that, unfortunately. But we need to get all the information up front and make sure we have a complete package when we go forward in signing any additional land development issues or something like that. But Jason, if you want to reach out to me, I'd be more than happy to sit down with you and talk with you.
All right, thank you.
thank you. Anybody else? Seeing none, notices the Board of Supervisors will conduct a public hearing immediately following this morning's regularly scheduled work session to consider and possibly render a decision on the application filed by James and Karen Fassel, applicants who seek to amend the final plan residential development PRD. Plan approval that was issued by the Board of Supervisors on February 21st, 1984 for the development known as Phase 1 of the Timbers located at 436 Timber Pass Drive, Downingtown, PA, described as TPN 32P-9. The applicants are seeking to amend the final PRD plans to allow the building of the property to be subdivided into 2 separate dwelling units. Also, the second notice is the Board of Supervisors will hold an executive session following this morning's public hearing to discuss legal matters. So I think we'll go off the record now and do the hearing.
Public hearing, yep.
If we're adjourning for the purposes of folks watching at home, this is where our video ends. Would you like me to record the hearing that's coming up in a second file?
I have no problem with it. I guess it's out of convenience for what's easier for you.
Okay, I'm just going to keep it rolling.
Sure.
But understand that the video will have ended
Sure.
when we went off the record.
So do we need a motion to adjourn the
Yeah,
regular?
you should motion to adjourn.
I make a motion, we adjourn the regular meeting.
I second. All in favor?
Aye.